Probably seen another round of layoffs in the news recently. It feels like it's been a constant cycle over the last couple of years. Large companies restructuring, reducing headcount, changing direction, and increasingly being challenged on how they're doing it. And alongside that, there's been a lot more focus in the UK on employment rights with the new legislation coming in. Ongoing reform, changes under the Employment Rights Act, increased scrutiny on things like fire and rehire, consultation processes, and how employers are expected to behave when making changes. It's very easy to look at all of that and think this is something that sits with large organisations, big teams, formal HR structures, in-house lawyers. But the reality is the underlying issues sit just as much with smaller businesses. They just don't make headlines in the same way. What all of these stories are really about is what happens when a business changes, and more specifically, what happens when the original arrangement you had with someone no longer works. Because when you hire someone, there's usually a very clear intention. You've got a role in mind, a need within the business, expectations around performance, and a sense of how things are going to work. You meet someone, they seem like a great fit, you agree terms, you put a contract in place, and you move forward. At that point, everything feels quite straightforward. But businesses don't stay still. Roles evolve, priorities shift, markets change, and people don't always perform in the way you expected when you hired them. And that's where things start to become more complicated. Because what you agreed at the start doesn't always reflect what the business now needs. At a larger scale, this can lead to company restructures, redundancies, and sometimes more controversial approaches like fire and rehire, where businesses are effectively trying to reset the terms of employment. That's exactly what's been under scrutiny recently and why there's been so much focus on reform. Because from a legal perspective, there's an increased expectation that businesses don't just make decisions, that they allow a fair and structured process in getting there. And that applies whether you're a multinational company or a business with 5 employees. In a smaller business, this just tends to show up more in the background. It might be someone not quite doing something that you need anymore, a role that has outgrown the person in it, someone is struggling, or a business has changed direction. And what I see often is that these situations aren't being dealt with early enough. They're left, hope they'll improve, avoided because they feel uncomfortable. And that's usually the starting point of the problem. Because by the time something becomes obvious enough that you feel that you have to act, it's usually been building for a while. And at that point, your options are much more limited. This is where the legal framework becomes much more relevant. Under the Employment Rights Act 1996, which still forms the core of UK employment law, employees gain protection against unfair dismissal once they reach the relevant qualifying service. Currently 2 years, although very soon that's going to change to 6 months. But what's important is not just that that protection exists, it's what it requires from an employer. Because the test isn't simply whether you had a reason to dismiss someone, it's whether you acted reasonably in treating that as a sufficient reason and whether you followed a fair process. And that's where most of the risk sits. Because what I see quite often is businesses focusing on the outcome and not the process. They reach a point where they think this isn't working and then they try to move quite quickly to resolve it. But legally, that's not how it's assessed. The focus is on how you got there. Were expectations clear from the outset? Was the role properly defined? Did the employee understand what was required of them? When issues arose, were they addressed? Was feedback given clearly and consistently? Was there an opportunity to improve? Was there any form of structured process, or was everything handled informally? Because if you don't have that structure, it becomes very difficult to demonstrate that you've acted reasonably. And that is where claims arise. This is also where probation periods come into play, and they're often misunderstood. Most businesses include them, but they're not always used properly. The probation period is one of the few points where you have genuine flexibility. It's your opportunity to assess whether the role works in practice, not just in theory. But what often happens is that probation periods are allowed to pass without any real assessment. There's no structured review, no clear decision point, no proper evaluation of performance. And once that period has passed, your position changes. Because from that point onwards, you're dealing with a much more established employment relationship with greater expectations around process and fairness. Another key area is how performance issues are handled. A lot of businesses deal with these informally. They might have conversations, raise concerns, give feedback, but it's not documented, it's not structured, and it's not consistent. And again, that just feels easier in the moment. It avoids confrontation, it keeps things moving. But from a legal perspective, that creates this gap. Because if you ultimately need to rely on performance as a reason for dismissal, then you need to be able to show that you had managed that properly, that there were clear expectations, clear feedback, and a fair opportunity to improve. Without that, it becomes very difficult to justify the decision. This is also where the increased focus on fire and rehire in the legislation becomes relevant, because what happens with that practice is that it highlights a situation where a business is trying to change terms after the fact, often because the original structure no longer works. And the legal and political scrutiny around that really is about fairness. Whether businesses are giving employees a genuine opportunity to engage with those changes or imposing them. And again, while most small businesses aren't engaging in a hire and refire in a formal sense, the same issue arises when you try to change roles or responsibilities or terms without proper structure. You're effectively trying to reset the relationship, and that needs to be handled carefully. Another area that comes up a lot is redundancy, particularly in growing businesses that need to pivot or structure. Redundancy is often seen as a straightforward concept. The role is no longer needed, so the person leaves. But in practice, it is much more complex because it's not just about the reason, it's about how that decision is made and implemented. Is the role genuinely redundant? Is there a fair selection process? Has there been proper consultation? And again, those are process-driven questions. And that's really the theme that runs through all of this. It's not about whether businesses can actually make the decisions. They can. It's about how those decisions are made and implemented in practice, and whether there's enough structure, clarity, and fairness in the process. For small businesses, the challenge is that all of this can feel very disproportionate and heavy. You're dealing with a small team, close relationships, a fast-moving environment. Formal processes can feel unnecessary or overly heavy, but the risk doesn't just go away because the business is smaller. If anything, it can be more exposed because there's often less of a structure in place. And that's why these issues tend to build in the background, not through one big mistake, but through lots of small things that haven't been addressed properly. Unclear roles, informal feedback, missed opportunities to deal with issues early, lack of documentation, lack of structure, and then eventually something brings it into focus. A situation that needs to be dealt with, often very quickly. And at that point, the business is reacting rather than managing. And that's always a much more difficult position to be in. Because instead of having a clear framework to rely on, you're trying to work out what to do in the moment. And that's where mistakes are much more likely to occur. What all of these headlines we're seeing are really showing is that employment relationships are not static. They evolve, and they need to be managed as they evolve. And the legal framework is increasingly focused on ensuring that those changes are handled fairly, not just in outcome, but in process. So for a small business, the most important thing is not to overcomplicate this, is to have enough structure in place from the start. Clear contracts that reflect how the business operates, proper use of probation periods, clear expectations, consistent performance management, not in a rigid or overly formal way, but in a way that creates clarity. Because if that clarity is there, most situations can be managed. If it's not, that's where risk builds. And that's really what sits underneath all of these stories. Not just what happened, but how it was handled. And that is the part most businesses don't think about early enough until they have to.